protect the rights of voters, there needs to be some certainty here. They need to know that here's the time frame for the results to be in so that if somebody does want to contest this election, that can be done fully and fairly. Remember, the contesting is done after the certification. You can protest an election before. It's one of the sort of the niceties of this. But I think that they will argue in order to protect the values of voters' rights, you have to have some certainty here, and this is what the legislature decided to do.
Okay. I want to go now to Tallahassee because our legal analyst with, I think, the greatest familiarity in Florida law is Stephen Guy. Stephen, can I ask you first, because you know these justices in the main, you know the Supreme Court so much better than all of us, are there any clues here to the instinct of the justices themselves?
Well, one of the clues you get is from the questions, very specific questions about where is the end of all this. In other words, they're asking David Boies to tell them if you are asking us to open up the process so that you can do hand counts into the indefinite future, how do we find an end point to all that? And in fact, if you do open it up to endless hand counts, how do you reconcile that with the statute that allows you to challenge the election after the results have been certified? They're looking for him to help them somehow craft an opinion, and I don't think he's frankly doing that very well right now.
And Justice Pariente kept asking, she wasn't the only one who asked, but she asked several times on show us where to go, show us where there's something in the statute, or show us something in legislation to give us guidance. Does this indicate to you that they are somewhat reluctant to go beyond what's already on the record?
I think it does indicate that, and I think it should be disturbing to the Democrats that it's Pariente that's asking those questions, because she probably has the most liberal attitude in terms of crafting decrees beyond the specific text of the statute of any of the justices.
Stephen, help us a little bit with labels in general. Everybody in this whole mess has been given a label. These justices were all appointed in one form or another by Democratic governor, or with the assistance in one case of the Democratic governor. What does that tell us about them politically?
Well, they're actually a fairly moderate to conservative crew. I don't think there are any justices that you could really classify as liberal in the northeastern sense. There are some justices that are more willing, perhaps, to craft broader decrees. I think Anstead and Pariente are in that category. But basically, it really is a fairly conservative bench. So I think that's one of the reasons you're getting a lot of very detailed questions, asking the lawyers to help them craft a specific decree, because they really do want to be very tight, very specific, tie the opinion to the statute, and not go beyond what the statutes give them to work with.
Can I ask you just one more question while you're standing there, without coming back to me? While you're standing there, can you ask you to be reporter, not just lawyer? What's all the shouting behind you at the moment?
There seems to be some Bush people on one side and some Gore people on the other side testing the lungs.
Standard procedure in Florida these days. Thanks very much. Cookie Roberts.
I think it's a draw, by the way.
Thank you very much. The justices are coming back in a little early, so I'm going to apologize to Cookie Roberts and ask her to tell us a little later on about congressional deadlines. We go back to Chief Justice Wells.
We'll now hear from the counsel for respondents, and I believe Catherine Harris is the first respondent, represented by Mr. Glock.
Thank you, Mr. Chief Justice. We are also representing the Canvassing Board and Commissioner Crawford, who is here as well.
Yeah, that's the Elections Commission Canvassing Board under the Chapter 102.
Yes, and for ease of confusion, perhaps, Mr. Chief Justice, we refer to as the Commission. I think if I could start with something that I think is a point that needs to be addressed. I believe that the problem that is created here, really, and as the questions of the court go back and forth, you can see it. The difficulty that we have here is not really a legal problem, it's a political problem. We have a two-tiered process in Florida as far as election returns are concerned, and that has to do with, first, the counting and the certification of ballots, and the second is the contest. And most of what you are being asked to deal with today is the problem that is created by the contest. And if you think about it, it creates an enormous number of problems as far as the court is concerned, a number of which have been addressed by the different justices. But if we start out from the point that what we have here, the Secretary has certified the first election returns that came in, then in between that time and Saturday, when she probably would have certified along with the Commission the overseas ballots, the stay was entered by the court, and naturally is respected by both the canvassing board and by the secretary. But the fact of the matter is that until such time as the certification is made, the process of contesting the election cannot stand. The question raised both by the Chief Justice and by Justice Lewis, which is what is the impact of the two statutes, is very clear. Mr. Boyce said that, it's all kind of one thing and you can really handle it one way or the other, but that's not true. For instance, the whole issue of the overseas soldiers' ballots can't be resolved until such time as the election returns are certified and a challenge can be made as to whatever standards are being used to not include those ballots. There are a number of other things that can't occur until that happens, and then the suggestion that the Supreme Court can set a date, although they're not willing to even suggest to you what that date should be, comes back to the point that what is it that they really need to have happen here? For the Secretary to be successful, all that has to occur is that the court lifts the stay and affirms or simply lets sit Judge Lewis's order. For the petitioners here to succeed, a number of things has to occur.
But Mr. Glock, let me get you to my concern.
Yes, sir.
Quickly. The concern that I have is that it's not, that we have a long-standing policy out of other courts of this state that say that the real parties in interest here are the voters. Now, what I want to know is that and this 112 has a provision which says that some voters' votes may be ignored. And what I am concerned about is in what is the boundaries upon which the Secretary or the Commission could exercise its discretion and have those voters ignored. And I pose to you that in this particular presidential election, doesn't it revolve around the Electoral College and the fact that the prejudice that's involved here is the prejudice of not allowing Florida's votes to get counted?
Well, Mr. Chief Justice, the beginning point here is that there are 6 million voters, of course, and the focus here is on 72,000 of them in 3 selected counties. The Attorney General started out by saying that the Attorney General's position is that all the votes in the state of Florida be counted. But that, of course, is not what is underway at this point. The problem with respect to the electoral votes in Florida only occurs if the status quo is maintained, if the votes cannot be certified, if the contest procedure cannot begin.
Well, would they have to be certified today?
Well,
under the federal scheme, is there a mandatory certification today?
Well, Mr. Chief Justice, is governed by Florida law as far as certification is concerned.
But what I'm concerned about is the ramifications under the federal statutes, which is your opposition says here is December the 12th, or 6 days before December 18th. Now, what I want to know is on what date does the Secretary take the position that her duty to certify those votes is going to be jeopardized, and what is the basis of that jeopardy if the votes aren't certified on X date?
Respectfully, Mr. Chief Justice, the Secretary is governed by the Florida statutes. She is mandated to certify the election results 7 days after the election and then to pick up the overseas ballots later. Now, the question that you're asking, I can't exactly answer, because what you're now balancing is the right of the counting process versus the right of the contest process. I can't, Your Honor, I don't know how to answer that question.
Is the rights of those voters who may not have their votes counted if we don't honor the recounted votes, and the rights of those of all the voters who might have their rights denied if the certification doesn't get in within the time limit and on the basis that it will be accepted under Title V of the 3 U.S. Code.
But respectfully, sir, at this point in time, the only bar to that is the stay order that has been entered by this court. If the stay order is lifted, the votes can be certified. Once the votes are certified, then a contest can take place if anyone wants to take a contest, and that may have to be done on an expedited basis. But the fact of the matter is, I'm sorry, sir.
Go ahead.
The fact of the matter is that all of the relief that is being sought here by these folks is basically relief that should be in the context of a contest when it's possible to have a record. A lot of the questions asked by Justice Pariente that have to do with record kinds of facts, there are no answers to, because there, of course, is the most fluid of records in this case.
Hasn't the local canvassing boards followed the statutes in regard to having a request for a recount and then making a count to 3 precincts or 1%, and then making a determination that on that basis a manual recount would follow?
Justice Harding,
haven't they followed the statute?
Justice Harding, the statute, what the statute basically says is you're supposed to certify 7 days after the vote is taken. If there is going to be a request, if the Secretary has discretion, which Judge Lewis, of course, found that she does, then that discretion has to be exercised either to permit or not permit late filings. Reasons were given to the Secretary. She sent a letter out. She asked for the reasons. They provided the reasons by 2 p.m. on the day after, on Wednesday, I believe, and then she promptly responded after applying them against a set of criteria that she had developed to exercise her discretion.
When did she develop those criteria?
You're asking me as a matter of fact, Your Honor, starting within probably an hour after Judge Lewis entered his decision, she asked for input on the kinds of criteria that would be appropriate for her to exercise her jurisdiction.
Is that rather unusual as for a way for an agency head to come up with a decision in this state to just come up with something within a few hours as to whether to allow something or not allow something?
Well, Justice Pariente, I was kind of refreshed because the agency had actually asked for legal advice on it and what the legal standards would be for her to properly exercise her discretion, and she was pushing against a deadline, so I considered it excellent, frankly.
But she didn't really exercise her discretion. What was said was that a reason that she was not going to recognize as a reason for late filing manual recounts being conducted in accordance with 166. There was no discretion exercised. It was in accordance with her prior legal decision that recounts that were not based on machine errors were not going to be allowed, and that was what she announced the day before.
Well, Your Honor, the decision that the opinions that come out from the Division of Elections, Mr. Roberts' group, is not exactly the Secretary. The Secretary is the one that had the obligation under the statute to exercise her discretion in this case. And what she basically did was she looked at the various criteria in challenging an election, and she looked at other criteria as well, and she said that a manual recount that is undertaken solely to solve voter error is not the kind of thing that is sufficient to allow a breakdown of that deadline scheme. That was the reasonable exercise of her discretion.
So what is the Secretary saying that the reason that these manual recounts were not going to or are not going to be allowed is because they're too late? That is, they were not in within 7 days after the election?
Well, two things, Your Honor. First, what she is saying is...
Is that number one?
Well, as you know, Volusia County complied with 200,000 voters. In 3 days, they did the recount.
So we have within the state's recounts one county that has counted those votes by hand, correct?
That is correct. And Justice Pariente as well, the Secretary and the Canvassing Board have no right to go beyond the certificate that comes from the Canvassing Board. And Volusia County did a manual recount, irrespective of what the Secretary may think legally that the board had the right to do that. Once those returns are certified, neither the Secretary nor the Canvassing Board can go behind them. So this entire problem that we have here today, irrespective of whether you buy into the concept that the Secretary has the right to establish standards and has the right to exercise her discretion, which we believe she does both under the case law and as a result of the order she was responding to from Judge Lewis, the fact is this problem could have been resolved if the people asking for a manual recount, right or wrong, had completed the manual recount within the time period set forth as they did in Volusia County.
So the Secretary then would have counted those votes within the totals if they had been submitted by November 14th at 5 o'clock.
Neither the Secretary nor the Canvassing Board has the power not to, Justice Pariente. They would have to do that. Now, you asked a question earlier as to whether or not there's any history as far as Broward County is concerned. Since, of course, there's not a record, I can't respond there, but of course, there is one case, which is the Broward County versus Hogan case, where the issue went up to the 4th District Court of Appeal on whether or not the canvassing board's decision not to conduct a recount was within their discretion, and they held it was. So I know at least on that one occasion that they did not exercise their right to conduct a recount. And you have to understand that the position of the secretary simply has to do with her understanding as to how the statutes are written. If you go back to the '88 race between Senator Mack and Governor McKay, the issue there was the problems that had arisen with the mechanical voting machines. That is the reason why the statutory amendments were created. And if you look through the statute, and taking respectful exception to the position of the Attorney General, wherever you see tabulation, they're basically referring to machine or electromagnetic, or however it's phrased, kinds of review of returns, and not actual counting, which is referred to differently. But the position of the Secretary is, if you look at those statutes, you can't simply pull the one subsection with respect to manual recounting out and pretend it's its own section. The fact of the matter is that the procedure is that if you have an automatic recount, which of course is done mechanically, you can then ask for the candidate and the party, not a voter, can ask for a manual recount. The manual recount, you have to go through the 1% and the 3 precincts.
Does the Secretary, though, play any role in determining whether or not there shall be a manual recount in any county?
Absolutely not, sir.
And so who has the authority and responsibility for that?
The canvassing board of the county has the responsibility in response to a request from a candidate or a political party to conduct a manual recount, which is this test.
Well, under the circumstances that we have here, then, isn't in essence the Secretary of State, who has no authority to determine that, overruling a decision by the proper body that has the authority to do that, to do it? Isn't that what the net effect of this is?
To the contrary, Justice Anstead.
Well, if the Secretary is saying, I'm not going to count the recount that started very late in the process and at a time in a large county where effectively the recount could not be completed before the 7 days were up, isn't that the net effect?
Justice, I don't know that the recount couldn't be done in that period of time. And of course, we have no trial record to know whether the recount could be done in that time.
Don't we also end up sort of discriminating between small counties and large counties? If we take Dade County, for instance, and Okaloosa County, clearly there's going to be a vast difference in the time that it takes in Dade County to do that manual recount compared to a small county. Would you agree?
Justice Anstead, yes. May I continue?
Yes.
The fact of the matter is the Florida legislature has all of this in front of it. It has an election code that understands that there is voting, that there's automatic recounting of voting, and that there are provisions for manual counting. They have considered all of that. It is part of the scheme. It has to be done in 7 days.
How do we know that they considered this specific issue with reference to a recount that is not started, for instance, until the 6 days after the election, and that they contemplated that in mandating that everything be in 7 days? How do we know that they considered that?
Justice Anstead, I'm sure they probably didn't consider the fact that someone would commence a recounting whenever they felt like doing it.
The scheme allows for that, does it not? The scheme allows for a request for a recount very late in the process.
The scheme, the fact that something, if you are permitted to initiate something at any point in time, and it has to be turned in at a certain time, that is the same basic rule that I had in high school with term papers. You can start the term paper the night before if you want to, but it is unlikely that you'll be able to turn it in the next day when it's due.
So by giving that right to initiate the recount at that time, that really is an illusory right. In other words, that is not really correct in the statute, that you have that much time before the certification of the results, in other words, to make that request.
You have the 7-day period within which to handle all of the counting of the votes, the initial counting, if you have an automatic recount, and if there's going to be a manual recount. But the other point, Your Honor, that I think is very important to note is that we're not talking about a manual recount on a statewide basis. It's 3 selected counties.
Let me talk about the 7 days, too, and ask for your help, and let's work by way of a hypothetical. Are you suggesting, by the language that has this 7-day deadline, that if we had, for instance, in Dade County, that the election officials down there, after they compiled the vote and everything, and they were the only county outstanding, and that there was gross negligence then, that they all went off on vacation to the islands and just let the election returns sit there. And 7 days passed, and 8 days passed, and 9 days passed, and 11, so on. That the Secretary of State, because of that 7-day rule then, and the gross negligence of the election officials down there, would simply say, that's it, and under the language of the legislature, I cannot count the votes from Dade County, the largest county in the state of Florida, in the election returns. Is that what the position of the Secretary of State is?
I don't believe so. Of course, that's not the situation right now.
What is the position?
There's a case
when we have a week past the deadline of 7 days, we have negligence on the part of the local officials, and they simply have not sent the results up to Tallahassee. What is the obligation of the Secretary of State?
Judge, we don't know that there's a matter of negligence. The court's assuming that.
I'm saying in my hypothetical, to assume it's negligence.
Well, we know from case law, if it's gross negligence, if it's a matter of marking up ballots or something like that, that the court has specifically held that can't be held against the voters. But Justice Anstey,
well, what would the Secretary of State do? A week has passed past the 7-day deadline. What would the Secretary of State do?
If she hadn't noticed that the Dade County results weren't in for a week, I think as a practical matter, the Secretary of State would be a little bit more proactive. That if the returns aren't in on a certain day, I'm sure inquiry would be made. If it was clear to the Secretary of State that there was gross negligence involved in not getting them in, she's bound by case law to accept them. Or, Your Honor, it would be raised in the context of a contest. But if we could get back respectfully, sir, to the situation that we're in here, the situation we're in here was not caused by the Secretary. The difficulty we have here, all we need to do is to be able to certify the election. Once the election is certified, the contest period can begin. The petitioners are trying to conduct a contest proceeding prior to certification, not for legal reasons, for political reasons.
How can a contest occur while the manual recount's still going on? As you just said, we don't know whether there is going to be an issue as to the integrity of how the recount was done. So how can that start before the manual recount is completed?
Because, Justice Pariente, you have to read all the statutes together. And one of the clearest things when you look at the statutes is the mandatory nature of certain actions that have to be taken by the Secretary. Not even the petitioners, Your Honor, could come up with some way of balancing between 166 and 168. And what the court is being asked to do is an extensive amount of legislation. I mean, you're going to have to do away with the 7-day rule. You're going to have to abolish 166. You're going to have to do away with the Secretary's discretion, and then the court enters the great universe of Chad to decide on the record that you have whether or not 2 corners are enough or 3 corners are enough.
I thought you said that the 7-day rule does not apply, that the Secretary of State has some obligation, if this 7-day period passes, to contact the county and now inquire into the circumstances of why the 7 days, and if she determines, for instance, that it's just the negligence of the local officials in failing to send the ballots up, that she can ignore the 7-day time and accept.
Your Honor, I'm not specifically sure what the Secretary would do. All I'm saying is the case law says if it's gross negligence on the part of election officers, that the votes will be counted.
But we do not have a situation. The 7-day period is not absolute then.
No, of course it's not absolute. Judge Lewis ruled that there was discretion the Secretary had to exercise, and irrespective of how we may interpret 111 and 112 as shall or may, we are operating under the ruling of Judge Lewis.
What was the position of the Secretary of State going before Judge Lewis as far as whether or not the 7-day rule was absolute?
Your Honor, from looking at the record, it appears that they agreed that discretion of the Secretary could be appropriate, that the may standard would probably trump the shall standard. That's my understanding of the position that he took. I don't know that that legally is correct. That's the position that was taken. And consequently, when the order came down, they lived with it. And that order, I might add, was perfectly happy. The petitioners were perfectly happy with that until such time as Judge Lewis ruled that the Secretary had not abused her discretion.
Justice Shaw has a question.
I'm sorry, sir.
If the state of Florida has provided a protest procedure, can the Secretary of State exercise her discretion under 102, 112 so as to frustrate that procedure?
I'm afraid I don't understand the Justice's question exactly. If the question, I'm sorry, I don't understand the question.
Do you agree that under 102, 112, that the Secretary has some discretion? What would be your position? That
I would agree, Your Honor, that based on the record as it is and the agreement of the Secretary to be bound by that, she has the right to exercise discretion after she establishes standards.
Can she exercise that discretion in such a fashion as to frustrate the scheme in which a protest can be lodged?
No, because the contest is under 168, Your Honor, not under 166.
Not a contest, a protest.
With respect to a recount?
Yeah.
Your Honor, all the Secretary can do is she has the right to be able to establish criteria for determining whether or not a late filing will occur. She established those criteria drawn from precedents of courts. She then applied the requests against that and found them to be wanting. As I said before, Your Honor, the entire problem could be solved if the certification had taken place on time because they had complied with the timing. That completely, of course, avoids, I'm sorry,
But
Justice
doesn't
Quinn.
that argument really blur the lines between a protest and a contest? Now, under 166, you can contest returns or protest returns within, the 72-hour period or the 7-day period under 166. Isn't that a completely different procedure from 168, which is the election contest? And it seems to me that your argument is blurring those two procedures.
No, and I apologize if it is, Justice Quince. I think that's exactly the central issue here. The procedure with respect to certifying an election is, as has been said by the Attorney General, mostly ministerial, okay? What has happened here is that
But once the certification is done, isn't that when the contest comes in?
Yes, ma'am.
Okay, but
yes.
the protest is a different matter.
But
you don't have to certify to have a protest.
We do not have any kind of procedure under Florida law for dealing with a full-fledged contest kind of action prior to certification. That's the difficulty we have here. And that's the reason why the court is being asked to engage in extensive statutory rewrites and then the entire issue of how you're going to make judgments with respect to these ballots.
Mr. Glock, let me follow up on Justice Quint's question. Why wouldn't it be, in this unique circumstance, a better thing to do to wait and unless there is a specific reason that's going to prejudice Florida's certification to the Electoral College, wait and see to a point in time when the manual recounts are completed. Allow those amended certifications to be made, and then there will be a point in time in which a determination can be made as to whether the contest in respect to those are going to jeopardize Florida's electoral vote.
Mr. Chief Justice, what you're talking about is making a value judgment as between whether or not the rights of 168 trump 166. On behalf of people, there's no suggestion anywhere here in the record that we have a problem with the voting machines or there was any fraud or anything else. What we're trying to do is to deal with the problem of people who did not follow instructions. The instructions were to put the stylus through the hole in the ballot. They did not follow those instructions. Now, balanced against that is being suggested that the entire contest period should be stood on its head and that the Secretary of State loses her ability to conduct her constitutional exercises. The legislature loses its ability. The Attorney General, for instance, points out all of the states that have elaborate statutes to make judgments on manual recounts. Well, that's wonderful, except the Florida legislature hasn't done that yet. Is this court to do it?
We've had cases dealing with this issue in Florida since the 1800s. And all of them in some way, shape, or form come about because voters do not follow the instructions. And in all of those cases that I have read, when you can look at the ballot, even though it is improperly marked, and even though the